we're going to be talking about the next section of the rules, specifically the lawyer's duty to the public and the legal system. This portion of the rules makes up 2 to 4% of your total MPRE exam. The first rule that I want to point out is about voluntary pro bono service. The rule states that every lawyer has a professional responsibility to provide legal services to those that are unable to pay. A lawyer should aspire to render at least 50 hours of pro bono legal services each year. To reflect upon this rule, the plain language makes it clear that this is aspirational, not mandatory. Additionally, remember that every jurisdiction has slightly different rules, and the MPRE exam is testing the ABA model rules. We see many students confuse their jurisdiction's rules with these model rules of professional conduct, and they get questions wrong. The next rule I want to point out is about serving in a legal services organization. The rule states that a lawyer may serve as a director, an officer, or a member of a legal services organization, apart from the law firm in which the lawyer practices, notwithstanding the organization serves persons having interests adverse to a client of the lawyer. However, the lawyer shall not knowingly participate in a decision or an action of the organization if participation in it would be incompatible with the lawyer's obligations to a client under the current client conflict rules or present client conflict rules. Stopping there for a moment. What this is saying is that you might work at a big, high-powered law firm during the day. And maybe by night, you're serving in some sort of legal services organization because you want to, and you feel like maybe it's your duty to participate in something like that. Further, maybe the law firm you work for by day has clients whose interests are adverse to the legal services organization's interest. And that's okay. The plain language of this rule says that is all right. Now, there are some limitations, however, on what you can do as a lawyer in this situation. The first limitation specifically says that you should not participate in a decision or take some sort of action if doing so would be incompatible with your obligations to the clients of your law firm, because doing so would likely create some sort of present client conflict. And I think this makes sense. While you should be able to use your time however you see fit by, say, participating in a legal services organization, you shouldn't simultaneously be hurting the clients of your law firm. The rule goes on to say that the lawyer shall not knowingly participate in a decision or an action of the organization where that decision or action could have a material adverse effect on the representation of a client of the organization whose interests are adverse to a client of the lawyer. I like to think that this prong of the rule is essentially evening out the sides here. You can't make a decision that would harm the clients of your law firm, your day job, but you similarly shouldn't participate in making a decision or taking part in some sort of action that's going to also harm the legal services organization or the clients of that legal services organization. So turning to an example in the outline on this point, it states, if an organization wants to pass a zoning law that would be incompatible with the wishes of a lawyer's client, the lawyer shouldn't participate. Or if the lawyer's participation in a vote would actually have the adverse effect on a client of the organization, but could be beneficial to the lawyer's personal clients, the lawyer should refrain from participating in that matter. The next portion of the rule talks about law reform activities that affect your client's interests. The rule states that a lawyer may serve as a director, officer, or as a member of an organization involved in reform of the law or its administration, notwithstanding the reform may negatively or positively affect the interests of a client of the lawyer. So let's stop there. I think it's helpful to remind you that about 99% of our law reform is not retroactive, but instead it's going to make changes to the future of the law in its application. And if you keep this in mind, then I think this rule makes a bit more sense. So let me give you a quick example. Sam is a criminal defense lawyer, and the bread and butter of her practice is drunk driving cases. She typically represents people who get caught driving over the legal limit. Sam is also active in a law reform group that is seeking stricter laws with respect to drunk driving. At a quick glance, you might feel like, wow, That feels incompatible. This feels like there's a conflict of interest here. How is Sam trying to represent people who are breaking these drunk driving laws, but simultaneously wanting stricter drunk driving laws? This just doesn't seem right. But pursuant to our rules, this is just fine. And that's because if that jurisdiction decides to implement stricter drunk driving laws, those laws are going to take effect and impact those people in the future. It's not going to impact your current clients. And therefore, there isn't a conflict here. The rule goes on to say that when the lawyer knows that the interests of a client may be materially benefited by a decision in which the lawyer participates, the lawyer shall disclose that fact, but does not need to identify the client. So this means if you're participating in some sort of law reform group, maybe you're an officer or just as a member of it, and there's some sort of action in front of the group, you're allowed to participate in the making of that decision, even if one of your personal clients will be benefited. But what you're supposed to do is you should disclose to the group that you do have clients or a client that would be materially benefited from this decision. But you don't have to disclose your client's name. The policy behind this rule is we want lawyers to be transparent in their participation of these types of activities. And then the final rule I want to touch upon in this section is all about the criticism of judges and adjudicating officials. The rule states a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or the integrity of a judge, an adjudicative officer, a public legal officer, or candidate for election or appointment to judicial office. So what this rule is saying is that you are definitely allowed to freely express your opinion and experiences about a judge, so long as they're rooted in some sort of knowledge or personal experience. If someone asks you how your experience went in front of a judge, that maybe you had a trial or a case in front of recently, you're allowed to explain your experience to them. This rule is not violated if you do so, but you do violate this rule if you're lying about a judge when someone asks you about them. For example, if someone asks you about Judge Smith and you don't like Judge Smith, so you lie, and you say that you don't think Judge Smith actually went to law school, this type of statement would violate the rules. So that wraps up our discussion on this section about the lawyer's duties to the public and the legal system.